Welcome to the Gerry Thinks What podcast. Part of the Lawyer Minds ecosystem, the Gerry Thinks What podcast discusses everything there is to know about trying cases, from preparing the case before the lawsuit is filed, all the way to trial. And most importantly, how to understand what the jury is thinking. During our journey, we'll be talking to some of the brightest trial lawyers from many walks of life. What makes them successful? What makes them different? Do they have secrets to dealing with the jury? Let's find out. Here's your host of the Gerry Thinks What podcast, Saul Gruber.
And thank you. This is your host, Saul Gruber, from Gruber Trial Consulting for the third season of the Gerry Thinks What, a podcast by trial lawyers for trial lawyers. And we're thrilled to start the new season with a personal friend from Indiana, from Bloomington, Indiana, Betsy Greene from Greene and Schultz. Betsy is a phenomenal trial lawyer. And she has been ranked in the super lawyer system, either one or two in the whole state over the last few years. And what you'll find when listening to Betsy is not only has she tried over 100 jury trials, but she just thinks the way we all wish we could think. Betsy is well known to be on the staff of the Trial Lawyers College, TLC, the Gerry Spence College, sometimes called. And she just has so many ideas and so many thoughts. We hated to end the podcast. I think you're really going to enjoy it. And you're going to want to take notes or at least listen to it or watch it twice. And again, this is the Gerry Thinks What, a podcast by trial lawyers for trial lawyers on the Lawyer Minds ecosystem. And here's Betsy. And we are starting the third season of the Gerry Thinks What, a podcast by trial lawyers for trial lawyers on the Lawyer Minds ecosystem with just one of the best lawyers in the country, Betsy Greene. Betsy is a partner with Fred Schultz in Bloomington, Indiana. And what I love about both of them, I consider them both friends, but what I love about both of them is if they believe in their case, if they believe in their client, they're going to trial, period. They don't want to hear anything about anything. If the defense or the insurance company doesn't respect their client, they're ready for trial. Don't you think, Beth?
Absolutely. Yes.
Thank you for joining us. Good to see you, Betsy.
It's great to see you, Saul, and thank you for inviting me.
I mean, the last we saw each other was a case we worked on together in Indiana with your partner, Fred, and a couple other lawyers, where we did some focus groups. But the real reason I wanted to bring you on is because I think you have such great knowledge just for all of our listeners who are thinking about trying cases and maybe haven't started yet. That's one of the things we always aimed when Tad Thomas and I came up with this idea to have this separate podcast from the rest of the Lawyer Minds podcast. We said, this is for people who maybe don't go to the AAJ meetings and get to hear people like you. And our solos, small firms that are, hunkered down till 10 o'clock at night wondering, what am I going to do? And this kind of gives them an ability to listen and collaborate with someone like yourself. Betsy, what's doing in Bloomington?
What's doing in Bloomington? Well, we're trying, Fred and I are, to keep everybody in line. How successful we are, it's hard to say. But I have to say, Bloomington, Indiana is my recharge. I call it paradise. It's a college town of about 85,000 people. We have a very local practice in some ways. In the other ways, of course, we have a statewide practice because we know people nationally and we get referred lots and lots of cases. So I kind of feel like I get the best of both worlds, right? I get to be a part of a community. I try a lot of cases. Well, before COVID, I tried a lot of cases here in Monroe County. So I feel like I know my community, but it's also a lot of fun to go out and practice in other counties.
So when I was doing some research on you, because you have to do some research no matter how well you think you know somebody. So I went and Googled you. And I saw that you've previously given an interview with Tad Thomas, who we both know very well, and we'll be celebrating in a few weeks his presidency in Seattle.
Yes.
And he asked you, why is it important for you to be recognized as a trial lawyer? And you gave just the best answer that I want to talk to you about. You said, I see a lot of people hold themselves out as trial lawyers, but I define trial lawyers as people who really try cases. What do you mean by that?
Well, what I mean by that is you can say you're a trial lawyer all day long. You can put an ad in the yellow pages or put up a billboard, and you can do this whole laundry list of tracking cases, wrongful death, dog bites. But if you really don't try cases, you're a fraud. And here's why. The insurance company knows, they know who tries cases and who doesn't. And I will have been a lawyer in October for 40 years, which is mind-boggling to me. But I have some ideas, Saul, when you think it might be appropriate, of what things that make a good trial lawyer. But just to answer your question, if you're not willing to fight, you're not a trial lawyer.
And I was going to ask you, so many people, so many younger lawyers I hear ask me all the time, how could I get better offers? I have never tried a case. What should I do? And my answer has always been, well, it's time to start. Why don't you take us through some of the things that you think is important and what they can do to become a good trial lawyer?
Okay, I love that question. And I could probably answer that question for an hour or so.
Well, I'm going to go get something to drink while you're answering. No, go ahead.
So I'm going to answer that, I guess, in two ways. I'm going to start with what makes a good trial lawyer. And honestly, good trial lawyers, you have to be able to listen. You have to like people and care about people. And maybe most importantly, Saul, you have to be willing to lose. If you're not willing to lose, then you're not really a trial lawyer, because you have to be willing to put it all on the line. And then what we do, contingent fee, it's not just your heart, it's not just your soul, it's not just your hours and hours and hours of work, it's your money and your time. And if you're not willing to take it to the mat, then you might want to be looking at doing something else.
I think that is so brilliant that if people don't realize it's brilliant, they just don't know. Because when I hear someone say, well, I've been trying cases for 30 years and I've only lost one case, my answer is, well, you're clearly not trying enough cases.
So the truth of the matter is, I don't try good cases. They pay me on good cases.
Amen.
Right?
Absolutely.
I mean, that's the truth. But you have to be willing to take it to the mat. And you know what? Sometimes that means really suffering. Because sometimes the jury, I've said this before, but I'll say it again. When I am done with closing argument, because the way I prepare, because of the things that I have learned, I feel like I have left it all there, right? Every bit of it. And I feel like I have taken my heart out and I have put it in the well in front of that jury box. And I have invited them to stomp all over it. And you know what? Sometimes they do.
Yeah.
But if you're not willing to put it out there, then in the end, you're not really a trial lawyer.
No, you would agree then. Listen how I asked that question. You would agree, of course. You would agree then.
Objection leading.
That you have to have some of the thickest skin as a trial lawyer.
It's not about you. It is about me, of course. Everything is about me. And of course, if I lose, I feel like it's all about me. And that's kind of part of what drives really good lawyers. But yeah, absolutely. You cannot take it personal. You cannot throw baby fits when the judge's ruling doesn't go your way. And oh, by the way, young lawyers, you cannot try your lawsuits by motion in limine, right? I mean, trials are a living, breathing thing, right? And even if it's a 1-day trial or a 3-month trial, there's a group of people that are together on a mission. And it's really important to be attuned to all that. If all you're worried about is what kind of show you're putting on, and you're not listening, and you're not relating, and you're not realizing what's happening in the room, that's going to be hard, and that's not going to work out very well.
I've always felt that too many lawyers who, I guess, learned how to try cases from watching TV, you think it's about what we as the lawyers are wearing, how we're acting, and really, the more we make it about us, the worse the verdict's going to be, because it's not about the client.
And here's the other thing, and this just kind of goes back. So, right, I told you I've been a lawyer for almost 40 years. So in October, like really close to 40 years. But I started as a deputy prosecutor. So I spent 5.5 years fighting crime. I worked my way up to chief deputy. I tried lots of cases all the time. I had to make decisions, and sometimes quick decisions. And I realized that I was really good at it and that I thrived on it. Even the suffering that goes along with losing.
Right.
I just thrived on it. So, but I learned a lot of other things too. And that is, like, first of all, you got to find your voice as a trial lawyer. I tried to be my boss for a while. She was so awesome, is so awesome. First elected female prosecutor in the state of Indiana. She didn't go into private practice. She became a judge and is now retired. But she was so fierce. And when I first started trying cases, I tried to be her, but it didn't suit me. I was a fraud.
And do you think that the jury will pick up on that right away?
Absolutely. When you're trying to be somebody else, or when you're reading a script, or if you're not doing what's true to you, they know if you're a fraud. And then as a plaintiff's lawyer, for me, trying cases, I want to be the trusted person in the room. I want to be the leader. I want everybody, including the judge and the court reporter, I want everybody to look at me. And when I say something, I want it to be true and useful. And maybe I don't win my objection, but
Right.
it's never going to be frivolous or stupid. I mean, it's important to me that I have the credibility, because I'm plaintiff. I have the burden of going forward. Even when I represented the state, I had the burden of going forward.
Right.
So I'm the person who I want the jurors to look to as a trusted leader. If I'm trying to be somebody I am not, I will be discovered as a fraud.
Mm-hmm. One of the things I always did when I was still trying cases was, and especially because most of them were nursing home cases after the first 7 or 8 years. So I'm only at 33 years as a lawyer.
You're getting it.
But the last 25 was all nursing home. We would provide the judge and the defense attorney this binder, which had all of the law, all of the regulations, all of the anticipated objections, the jury charges, everything that was bait stamped, in the hopes, and it normally worked, where the judge would just say, well, let's go to Mr. Gruber's page this, and everyone would turn to it. And when all he or she has to do is say that once or twice in front of the jury, then they look at me as if I'm the one they should listen to.
And you were the one who put it together, and you put it together fairly, and you put it together based upon the rules of evidence.
Yep.
And the defense can't really argue about it because it's all admissible. And judge puts it in, and then, yes, we'll turn to Mr. Gruber's.
I mean, that was always, we always did that. We wanted to make sure no matter what, they looked at whoever was from either me or from our firm. We were the ones who knew what we were doing. We were the ones who were always prepared, never fumbling.
Right. So I have to confess, I have never defended a case. I don't have a lot of perspective on the other side.
Me either.
Maybe I should, but I don't. That's not
too
what
late.
I do.
It's too late.
Yes, too late now.
It's definitely too late.
But I love the being able to go forward, and you build your credibility. Like when a judge sees my name on the jury list as the lawyer, I want them to smile. Doesn't mean that I'm not going to argue fiercely for what I think is right, but I never misrepresent. I'm very conscious of my burden of going forward, and I'm very conscious of the duty of credibility.
Now, do you think, going back to what we talked about before, that if you're going to try cases, you're going to lose cases? It's a simple fact. Do you think the fact that you do lose cases has any impact on an insurance company or a defense of whether they're going to pay you?
The fact that you're willing to try them is the factor. I mean, I've had some cases I thought, I thought, and you know what? That insurance adjuster sat and watched, and they thought so too. And maybe it turned out okay for them that time.
Right.
But I certainly proved that I know how to try cases, and you don't need to make me do them just to show I can. Because if you're willing to go to trial, then you show that they have a risk in dealing with you.
I couldn't agree more. And that's what I tell people all the time. When they say something like, how do I get bigger settlements? I said, well, try more cases. So when I look at you, Betsy, and when I listen to you, when I talk to you, which, is a few times a year at least, I think of one thing. Well, I think of two things. One is your husband, Jeremy, but the one thing I absolutely think of is the Trial Lawyers College. When I look at you, now that Carl Bettinger has retired, to me, you are the embodiment of TLC. Why don't you tell us a little bit about TLC and how you first got involved with them?
Oh, it's such a great story. So I'm going to do an abbreviated version. There's
Sure.
longer versions. But long and short of it is, I was a deputy prosecutor for 5.5 years. I got a call out of the blue from a man who was building his personal injury practice at the time, and he needed a trial lawyer. He was smart enough to know he could not try his way out of a paper bag, and he needed somebody to try cases. So he asked around local judges, and by that time I'd been a special prosecutor in several courts, and I'd been around for a while. So anyway, he got my name, and that's how I came to be a personal injury lawyer. I actually thought I was going to be a prosecutor forever. I really enjoyed doing the right thing. I really enjoyed crawling around looking for bullets at 4 a.m. I know, a little crazy, but I enjoyed it. But I also loved becoming a plaintiff's lawyer. And at first it was great. He really wanted me to be a good lawyer, and I got active Indiana trial lawyers, and I tried cases all over the state of Indiana. I'm fond of saying, have briefcase, right? Have briefcase, we'll try. I mean, all over. But then it just got to be too much, right? He went on TV. He didn't hire me enough help. I was doing the best I could for my peeps, but nobody at some point, it was too much. So my old boss was a huge Gerry Spence fan. A Gerry Spence fan, and by the way, a Bobby Knight fan. For those of you who don't know, Indiana University, Bloomington, Indiana, that's where we live. He was our coach, 3 times national champion. So my old boss would call me in and say, well, what would Bobby Knight do? Or what would Gerry Spence do? And so I read all of his books, and ultimately, my old boss sent me to a regional seminar in November of 2004, and I met Gerry Spence in the Trial Lawyers College. It was a life-changing experience for me, not because of Gerry necessarily, but because of the college and because of how people treated each other and because of the philosophy and the premises that I'll talk about in a little bit. But to me, it was like, be real, be yourself, put things in action, discover the emotional content. To me, it was a revelation. So I went back to my law practice of 16 years and quit my job. I do not recommend this. But but it was the best thing that could have ever happened to me. My law partner was still working there, but I quit my job, and then 6 months later, he came and joined me. So after I quit my job, I applied for the 3-week college in 2005. And I went to Thunderhead Ranch in Du Bois, Wyoming, and spent 3 weeks studying with Gerry, Spence, and the Trial Lawyers College. And
Now, everybody I know who has been to the Trial Lawyers College will say, and that's a lot of lawyers that I know who've been to the TLC, will all say to me the same thing. They'll say it was life-changing. I look at everything different.
Mhm.
I'm from New Jersey. We poo-poo everything. I'm like, yeah. Then when Jersey lawyers started to come back, say to me, it changed their life, and they're now getting 7-figure verdicts. I said, well, okay, now I have to listen now. Tell us a little bit about why it changed your life. Like, what were you doing there that turned you around, so to speak?
so the foundation of the Trial Lawyers College is psychodrama. Psychodrama was invented by a man named J.L. Moreno. I've studied about him. I've read a lot about him. You don't have to study and read a lot about him, but you need to know that in the early days of psychology and psychotherapy, there were a couple of different schools, Freudian and Moreno, who was Austrian and came to America in the 20s. Moreno is credited with developing group therapy, improvisation. He was all about the theater. But from our perspective, it was psychodrama. So psychodrama is a therapeutic form. And when Gerry first founded the college out at the ranch in 1994, he had psychodramatists, Don Clarkson and John Nolte, shout outs to both. He had psychodramatists there, and the lawyers did do the therapy, but it was mainly a gift to them. Gerry's idea and the Trial Lawyers College idea is that you have to discover yourself. It all begins with you. And until you know who you are and you can analyze your own reactions to your own clients and be true and real, you're not really going to be able to relate with yours, and you're not really going to be able to get the results you want. As time went on and the Trial Lawyers College developed, Gerry and the rest of the faculty, because in the beginning it was all a bunch of famous lawyers like Racehorse Haynes and Joe Jamail, and Johnny Cochran was out there. I mean, in the beginning, the first couple of years, Gerry invited super famous lawyers to come out to the ranch, and then the young lawyers. But as time went on, the college decided they developed their own faculty. And what Gerry and the faculty realized is that we can use these principles of psychodrama in our trial work. And the idea is that we put things in action. It's compelling. It's our trial skills. We use the psychodramatic techniques to tell a story in a way that is compelling, truthful, human, and real.
How do you do that? Because I told you earlier that my first experience with it was with Carl Bettinger, great lawyer, great book. If anybody has, I think it was called 12 Heroes, phenomenal book, still on trial guides. And Carl was one of our leaders in the nursing home world. And he was my first instructor at a trial college back in the, I guess, early 2000s through AAJ. And he just scared me to no end when he did the psychodrama. Just scared the living you-know-what out of me. And I'm like, oh, boy. So tell us a little bit about that.
Okay, I will. First of all, Carl also taught my class.
Oh, okay.
I admire him so much. And I should probably say that I spent from 2005 I went back for seminars. I did our local groups. I put this stuff in action in my own cases, and then I got my faculty invite in 2010. So I studied with, worked with, and came to know Gerry Spence very, very well for years. And the whole faculty, Carl being part of it. So how do we do it? Okay.
I'll make it even easier for you. I'm a lawyer. I have a car accident case, right, which a lot of attorneys have. She was rear-ended from behind. She fractured her neck, and slowly is regaining all of her faculties. And the defense says that she's a fraud, and the tests really are all BS. And her problems are temporary.
Okay, so here's what we do. First of all, we have lots of skills that we teach, right? Discovering the story, jury selection, voir dire, as we say in Indiana. Voir dire, you may say in Jersey.
We definitely say voir dire.
We definitely say voir dire in Southern India. Opening, closing, cross, direct. No, I'm sorry. Opening, direct, cross, closing. So the keystone and my favorite skill is discovering the story. So how do you tell a story until you find it? So this is a collaborative method. Ideally, you have a group of people. Now, sometimes, for example, we train public defenders, and if they've got somebody who is charged with a capital crime, well, they're not going to get to come to a law office with a group of lawyers. So things can always be adapted, right?
Right.
I have prepared for depositions just reversing roles sitting at my desk. So you don't have to have a bunch of people, but ideally the collaborative effort is you get a group together. It doesn't have to be lawyers. Now, my group, we try to meet once a month and a half for probably about 15 years. But in the beginning, I didn't have a bunch of lawyers. We didn't have very many grads. I think I was the third trial lawyers college grad in Indiana. So I just had friends. I had like my husband, my legal assistant, a friend of ours who owned a restaurant. He used to love to come to our sessions. And then you swear everybody into confidentiality. And we don't do therapy, but we do reenactments.
Right.
What do you need? You need, ideally, again, this can all be adapted, but ideally you need a director, which typically is me because I'm very well trained, or that would be sometimes you would bring in or pay a hired consultant psychodramatist. Like, for example, I would never, ever reenact an assault or a sexual assault. I would be very careful about what I do. But what we do is you have a director, you have a stage, you have a protagonist, which usually is going to be the lawyer, but sometimes it's the client. And then you have auxiliaries, or you have a group. And literally you act out scenes. The director will help you, somebody who's trained in psychodrama or even just trained in the trial lawyers college. So what tools do we use? We use role reversal. Number one, probably the biggest, most important thing. Make every effort. Reverse roles. Do you have a difficult judge? Reverse roles. What's that judge thinking? What's that judge bring to this? How can you relate to that judge as a fellow human? How can you perhaps understand or meet them where they are? So role reversal, hugely important. Scene setting, probably should have said that even before role reversal. So like my best tip to all of you out there, there is no argument or no examination that cannot be made better by the simple use of present tense.
Yes.
Immediacy. Tell the story. Let's think about like how you watch a movie. We don't tell people, well, their back hurt and they couldn't move. Let's have somebody tell a story about a time when the client couldn't do something or wasn't able to move because of the pain. Let's not narrate and tell people what they should think. Let's show them. And with the showing, that's where you start to relate, right? We relate to people on an emotional level, not on a, I'm going to tell you what you should think.
When you're setting that scene or showing them is the better word, do you like to show them through the plaintiff, or do you want other witnesses to be there to show them?
So you can do that. That's the beauty of it, right? Because it's creating a show. It's creating think about it as creating a movie or a TV show. And you get to pick the scenes, right? What's going to be most compelling? What's going to reverberate the most? So like scene setting is so awesome because so many people, when they're doing like direct exams, I don't know if I can give them, people are just kind of hanging out there, right?
Right.
Like, oh, well, how are they different now? Okay, that might be useful, but isn't it more useful to put somebody in a place maybe where they live or they care about, or who's in the room? Is it the wife who has to who has to help because husband is just gassed from just doing all he can to work? What I mean,
Right.
what is so that's where I think
So instead of asking the question, is there anything you can't do as well anymore that they did before the accident, which everybody asks, and it's horrible, actually show them, have people talk to them about the differences, what they see.
right. Now, typically, I'm not going to want my folks to be doing much of that.
Right. When you say your folks, you mean your plaintiffs.
Yes,
Yeah.
sorry, my peeps, my whoever's, my clients. I don't usually think of them as clients at that point, my friends.
Right.
I'm typically going to look, so that's so important. The before and after witnesses, use them. Don't ask them, like, don't get 5 people up there. Well, how are they different now? Have people choose people who can talk about different aspects, maybe a coworker, maybe a neighbor, maybe a family member, but have them talk about different aspects and don't talk about generalities. Put them in a place. Can you think of a time that you could share with this jury when you saw the effects that this wreck had on Mr. Plaintiff or whatever it is, right?
Right.
It just makes it so much more real. And people can, we humans are hardwired for story, right? I mean, we're just hardwired.
Yeah, absolutely.
And so if you can show a compelling story about a real human, it's so much. I mean, you just open the door and let the jury come meet your plaintiff where they are. And no, they're probably not perfect. And yes, there's probably things the defense can pick at. But once you understand somebody as a human, you can hear them and accept their pain, their suffering, whatever they've been through, and it helps ward off that innuendo and bullshit from the defense.
Right. The innuendo and bullshit. That's a good quote. That's what we go through. You're absolutely right. That's a defense. That's defense game plan. I guess that's what happens when you don't have a burden of proof, right? You can get by with innuendo and bullshit.
Yeah, you get to just throw stuff up against the wall and see if it sticks, right? But I can't do that. As a plaintiff's lawyer, oh my gosh, I couldn't possibly do that. That would be wrong.
One of the things we did do years ago in our intakes when I was still practicing in New Jersey is immediately during the first visit with the family, a lot of times the person who went through everything wasn't alive anymore, is who could tell us about this? We would have them so close to the incident, any name they had, anywhere, and then we would try to develop it and discover it.
Well, that's another good point. So because I'm so trained in these methods, there's many times the very first time I meet a client, I just say, this might seem a little different, but I want you to show me. Let's act this out. I remember one time it was a fall down at the local Kroger. I mean, I have so many examples, but so it was fall down at the local Kroger. I mean, it just happened maybe a week before. She did not have any health insurance. She had to be operated on, so she's got her arm in a sling. And her husband was with her at the Kroger, and he came in to my conference room, and I'm like, let's scoot these chairs out of the way. Let's use this space. And I literally set the scene. We set up the produce tables. What had happened was there was a pallet sticking out from below. It wasn't even like a grape on the floor. I mean, it was just outrageous because she wouldn't see it. And anyway, so we acted it all out. What happened? How do you feel? What do you see? What do you smell? Who's there? You can actually find out factual discovery when you put people back in the place in a trained way and direct them to speak about and to show you what happened, and also to explore the emotions. So I'll never forget at the end of this, I'm like, please don't hurt yourself, but will you get down on the floor? And literally, like, after we acted this out, she got down on the floor and she's laying there, and literally tears just started rolling down her face. And she was like, oh my gosh, I feel like I'm there. I'm embarrassed. I don't want anybody to know. I'm hurt. I don't understand what happened. I mean, these are such compelling, real things. And sometimes you just don't get that by the traditional question and answer.
Right. Would you ever have them do that in a courtroom?
Yes, absolutely. I haven't had anybody reenact a fall down, but I've reenacted lots of car crashes in the courtroom. Yes. Just make sure that you're prepared, make sure that your client's prepared, think it out ahead of time, like any other demonstrative piece of evidence.
Right.
Know where your jury is, know what you're going to do so that the judge will keep letting you do it. Absolutely, I would put things in action in the courtroom.
What about the thought process that a lot of lawyers have that I don't even think I've gotten over yet is, I'm going to look stupid in front of everybody, and I don't want to look stupid?
Okay. My answer to that is prepare. I mean, that's just my answer. And then, like, never take a risk that's not justified. Never do a demonstrative piece that you have not thought out.
Right.
I do not take my clients through the demo over and over because I don't want it to be rehearsed. I want it to be real. So you got to balance that. But, here's what we say at the Trial Lawyers College, right? Take a risk.
Yeah.
And if you fail fabulously.
That's wonderful. That's another
Jump
brilliant
off that
quote.
cliff, right? Because you will never, if you don't try, if you aren't willing to take the risk. Now, mind you, prepare. I'm not saying go walk in and wing some demo. That's not at all what I'm saying. But don't be afraid to take the risk, right? Because it's not about you. It's about your client.
And that is such a hard concept to grasp.
Yeah.
The truly great ones, like yourself, actually. I mean, the truly great ones get that it's just not about us. It just isn't. We're not the star. We're the director. The play that our clients are. It's all that matters is how it affects the client.
And we need to be in service to the jury.
Well, yeah, without question.
That's the other thing I think a lot of trial lawyers don't understand, because they get so wrapped up in what they're going to say and how they're going to say it and all of that. But prepare. What does your jury need? how can I, as plaintiff's lawyer, be in service to what the jurors need to make the right decision?
Let's talk about that for a minute, because, I preach that and have been preaching that forever. And that's kind of my new profession, as you know.
Yeah.
How do you go about figuring out what the jury needs and what you need to give them, more importantly?
So there's I think a multi-step process to that these days, honestly. And of course, different courts are different. So for example, in Indiana, in Marion County, which is Indianapolis, I don't get my jury pool until 30 minutes before I'm going to go up and talk to them. So that creates some different issues. Most of the time, in most counties, I'm going to have that jury list 2 or 3 weeks ahead of time. So what I do, and I think it would be malpractice not to, even though maybe it's not trial lawyers college necessarily, but literally I run them through Google. I run them through the public records, because after all, if somebody's got like 15 collection cases, maybe they're good for you, maybe they aren't, but you ought to know. By the way, I don't ever let them know I know.
Sure.
So there's always there's sort of the backstory that we can do now that we couldn't when I was when I was a baby lawyer. Well, hell, probably the first 60 cases I tried, I could not do that.
Not only couldn't you do it, you got the names, I don't know, 8 minutes before they were brought in.
Now, see, except for Indianapolis, I've always.
Oh no, we would literally be given the list as we're sitting in the court, and they're bringing 1 to 30 in. You're like, oh,
yeah. All right. Well, so that's the other piece, right? Maybe you can't always do the pre-research. I feel like if I have the opportunity, I have to do that.
Sure.
I remember the first time I did that, I think it was back on MySpace. I don't even think we had a Facebook back then. The first time I did it, I actually knew the name of one of the jurors' cats because she had an online diary. Now, I wasn't going to tell her that, but I knew. But so put all that aside, though. How do you really know? You talk to them. You ask them. And it's not about you talking at them. The art to jury selection is be credible, be real, share something real. That's the trial lawyers college. How you genuinely feel about a danger point in your case. And then share that and hopefully begin a discussion. Never argue with anybody. You're never going to change their mind.
Right.
And but if I showed you this, then would you do that? That means the 3 people sitting next to them are not going to tell you.
Exactly.
What they think, right? So the art, I think, how do you know? Well, I don't guess you really ever know. But I think the more that you are open and have a dialogue and a discussion, and people are open to you and keep talking, I think you get to that place where you do know who's going to be for you and not.
And one of the things that I've heard a lot, I was hampered my entire career because in New Jersey, we have judge-driven voir dire.
Which is, I can't even imagine.
In about 10 years ago, the Rules Committee changed it to we could have 3, that's right, 3 open-ended questions. And no judge would like any question we would provide. They would say, you're trying the case in voir dire. And I would think to myself, yeah, well, I'm trying to find out what they think of it. Sure, I'll give you that. So getting back to that point, I can still remember Carl, and I don't mean to keep talking about him, but he was my real into the TLC. I remember he would sit with his arms open palmed to his sides. He would stand, so it would be in a vulnerable position, and he would look at the jury, and he would say something like, in the way Carl could do it, that I could never do it, in a meek voice. I'm going to be honest. I'm scared right now. I'm nervous. You may be too. And, and I would watch that and say, look at people to my left and my right. I'm like, I could never do that. I just could never do that.
See, that's how humans connect. we really connect about emotions, not over facts.
Right.
And so sometimes when I do jury selection, I've sort of developed my own sort of TLC thing, but sometimes I'll stand up and I'll just look at the jury and I'll greet them all with my eyes. And I'll do this because I'll just try to tune in. It's like John Nolte used to tell us, did you know this? I did not know this. If you put 2 grand pianos in a room and you hit middle C on one, it will vibrate on the other, right? So I try to listen with my third ear. And so sometimes I will say, I'm feeling really anxious. And I'm wondering how you all might be feeling. And maybe you might be feeling lots of things, but you want to share one. That's a beautiful way to get a group of humans together. Plus, they're intrigued, right? Because that's not what they think they're going to get.
Right.
Yeah. That's how by being vulnerable. And of course, you could.
Oh no, I've been in so much therapy in the last 4 years. I could definitely be vulnerable now. I mean, when I was still trying cases, I don't know if I could have. Back then, I was so, it would take years for me to tell you all my issues. But back then, I was so panic driven. I didn't realize it, that I didn't want to share any perceived weakness with anybody. Right? It's not until you realize that's what brings us all together.
Well, and here's the other thing. So I've been teaching, I told you, I've been teaching at the Trial Lawyers College since 2010. Literally, I have taught almost every class, not everyone, because we did 2 a year. Sometimes I couldn't teach 2 a year, but I take so much joy in it. And I feel like it's a way to pay it forward, but it's also a way for me to learn, to keep learning. And so what I've learned is, especially like when you're just getting up and trying the trial lawyer's method, and I'm working with a student, we don't want to hear what the jurors have to say because we lawyers are control freaks.
Yeah.
So we ask these really pointed little narrow questions just in case, because we don't want anybody to. And of course, that's ridiculous, right? Because how are we ever going to know how anybody feels about anything unless we let them answer?
Yeah, so that's the truth. And don't try to convince them of anything. In fact, the more they tell you you're wrong or they would never agree with you, the better it is.
You're like, right. That's now what we've come to learn, right? Because we want to give voice to the nightmare juror.
Sure.
We want to hear all that stuff. And then we want to hear about their fellow panel members' feelings about what they said. And ideally, from my perspective, the goal is in jury selection, I just want to be leading a discussion.
Mm-hmm.
I want it to be the jurors talking, because that's when we're really going to find out how they feel and what they think. And I got to tell you, Saul, my law partner, Fred, is the absolute best at TLC jury selection.
I could see that.
He just takes it, right? Everything. There's no arguing. There's no fighting. There's no, but if the judge told you this, you would follow the law, wouldn't you? I mean, how insulting is that, by the way? To say,
and not only that, I never understand why anybody would ever say that. I would rather them say, no, I'm not going to listen to the judge.
Exactly.
I'm going to do what I think. And thank you. That's all I got for that guy.
Exactly. Yeah. Yeah.
Well, Betsy, I've taken enough of your time. I could tell you and I could talk for the next 2 hours.
We could.
And we probably will in a couple of weeks. And enjoy it. Again, I just want to thank you so much. If lawyers are listening to this and they want to know more about talking to you about an Indiana case, or just as important, talking to you about the TLC, what's the best way for them to get a hold of you?
www.greenschultz.com, but it's GREENE. Don't forget that E in the middle or you won't find me. And then the other place is triallawyerscollege.org, which is It's an amazing group of people and amazing educational experiences.
Well, again, thank you very much, Betsy. I really appreciate you coming in and just giving us just a thimble of your knowledge.
Good to talk to you, Saul.
As promised, Betsy lived up to everything we talked about in the introduction of her. She is an accomplished trial lawyer, but more than that, she cares. And she cares about not only her clients, which she'll fight for to the end, but she cares about people. And I hope it came across in the podcast, because I can tell you, it comes across every time I'm together with her. She's one of those special people, and she'll be happy to help anyone who calls. So if there's any question you have about referring a case in Indiana or the Trial Lawyers College, just give Betsy Greene a call and email, and she'll be able to get right back to you. And if you have any questions or need any help, we're always available at Gruber Trial Consulting, and we'll see you next month.
That concludes another episode of the Gerry Thinks What podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.